Deputy Kyne.
Okay, thank you, Seán Kyne. And I'd like to as well commend the Minister for his considerable work on this very important area, and I know he has considerable interest in this area, and certainly he's put a lot of work into this bill. I commend him for it. I believe this bill will obviously reinstate the system of registering collective agreements and will provide for a new system of registering employment agreements in certain sectors. And it also contains measures to put in place collective bargaining rights. And as a member of the Oireachtas Committee on Jobs, Enterprise and Innovation as a TD for the Galway West Mayo South, I have engaged with business, particularly small to medium enterprises, but also to larger companies, to employees, employers and workers indeed, that it is clear there is a balance needed to be struck on the issue of registered agreements. Our recovery is strengthening, employment is increasing, state revenues are up, but the recovery is fragile, and we cannot put in place inflexible arrangements that would endanger job creation and job retention. However, it's also clear from a number of high-profile cases that we also need to ensure that legislation helps contribute towards a sense of security and certainty for workers, certainty in pay, in working hours and in working conditions. And making work pay is a key policy of Fine Gael, and gainful employment in sustainable jobs is vital. Work should always pay more than welfare, and I view this legislation in that light as part of a number of measures underway to encourage a job creation that is sustainable and turnover which a person can support himself or herself or the family. Other measures include the establishment of the Low Pay Commission, the reform of the state's workplace relations organisations, and the introduction of the Back to Work family dividend in the last budget, which is particularly welcome. This bill today is another example of the reform introduced by the government that has unfortunately often been overlooked. The reform of the pre-legislative stage is certainly welcome because it provides for that scrutiny and the process of engagement with the interested parties, and has really opened up the legislative process. Last autumn at the Oireachtas Committee, we engaged with stakeholders on this issue, specifically the general scheme of the bill, and I've been encouraged by the government's motivation to provide more clarity, harmonious industrial relations, and to establish a more constitutionally robust regulatory framework. Following the stakeholder hearings with a range of groups, including IBEC to the Labour Relations Commission, Construction Workers Alliance and others, our committee compiled a report and submitted this to government. And the department then considered a number of the issues raised in that report. And some sections in particular stand out. Section 7, which concerned registered employment agreements and instructs the Labour Court to register agreements only where there is all-party agreement and in cases where the court is satisfied that the trade union is substantially representative of workers in an organisation. On the flip side, Section 18, which concerns sectoral employment orders, will extend advantageous benefits and conditions to workers in a sector, even if they or their employer party to Labour court proceedings.
Could I ask you, Deputy, to move that the debate be adjourned?
Yeah, I move that the debate be adjourned.
Thank you, Deputy.
Industrial Relations Amendment Bill 2015. Deputy Seán Kyne is in possession. You have 2 minutes remaining, Deputy.
Yesterday I was commenting on some of the standout provisions of the bill in relation to, for example, Section 7, which concerns registered employment agreements and instructs the Labour Court to register agreements only where there is all-party agreement and in cases where the court is satisfied that a trade union is substantially representative of workers in an organisation. On the other side, Section 18, which concerns sectoral employment orders, will extend advantageous benefits and conditions to workers in the sector, even if their employer are a party to Labour Court proceedings. Section 20 of the bill is also significant because it is providing a mechanism to allow a business owner or employer to apply to the Labour Court for a temporary derogation from the requirements concerning pay levels set out in the sectoral employment order. This, it must be pointed out, is for businesses experiencing temporary financial difficulties. I think that is an important area for businesses who are experiencing difficulties, that they do have this option here in relation to the sectoral employment orders. It provides flexibility and is an issue that I have myself raised at the Oireachtas committees. In times of financial difficulty for a business where jobs are under threat, we should not put in place a system which would compound this threat. And Section 20, I believe, will enable a business owner and the employees to work together to save the business and bring it back to viability. An example would be where everyone in the business taking a small pay cut rather than letting a fellow colleague go. And this type of flexibility that we need to ensure job creation and job retention. The benefits of the bill, obviously, for workers, the legislation will ensure that where there is no collective bargaining, they will have an effective system that ensures they can, air grievances about pay, conditions of employment in the Labour Court. And for employers, the legislation will provide a clear and balanced mechanism by which fairness of the employment conditions of workers can be assessed where collective bargaining does not take place. So overall, Minister, I'd like to again commend you for the work that you've done on this bill and wish you well in the passage of the legislation through the House. Margaret.